Hello, everyone, and welcome to this edition of Coffee with Craig, where we talk about all things firearms, firearms policy, politics, culture, media, you name it. We're talking about it right here on Coffee with Craig. So please take a moment, like and share the program so that your friends can know exactly where the conversation is taking place. Also, if you haven't already done so, please remember to subscribe to our YouTube channel and follow us on Facebook, Instagram, and Twitter. And in the case of YouTube and Facebook, make sure that you hit the notification button. That way you can get notified as soon as we go live, and you can participate in the live chat as the program is taking place. Also want to encourage you, if you haven't already done so recently, make sure you visit fpcgear.com. That's fpcgear.com. It is the place to go to get all of your Pro 2A swag. I'm talking t-shirts, I'm talking coffee mugs, I'm talking hoodies. It's all right there. And the best part about it is every dollar that you spend goes right back into the fight for our right to keep and bear arms. So you can support the Second Amendment and you can look good doing it. That's fpcgear.com. All right, talking about fighting for our rights. You know, we talk a lot about a lot of different things. We talk about kind of general ideas and principles. We talk about specific policy on this program. And then we also talk about instances and examples and cases where those rights and principles actually have played out. And then we also talk about the work that we do here at FPC. Well, today's topic is an example of all of that put together, right? It's literally talking about principles, it's talking about policy, it's talking about specific examples and work of the Firearms Policy Coalition. But it was so outrageous. I mean, this is something that is quite frankly so outrageous. This is something you will not hear in the mainstream media. They are not talking about it at all. But it is a very, very, very big deal. All right, so here's what happened. This occurred in Sacramento County, California, or actually it's Folsom, the city of Folsom, which is in the county of Sacramento. It's not too far from where this program is produced. I mean, we're talking, it's right up the street. I know exactly where Folsom is. But so here's what happened. So there's a gentleman. His name is Mark Coleman. In fact, we'll kind of get into his what happened. So this has to do with a case of a gentleman named Mark Coleman. Now, let me explain to you exactly what happened to Mr. Coleman. So Mark Coleman was going to a marriage counselor. He was seeing a counselor for help him be a better communicator within his marriage. He arrived at his doctor's office, which was in Folsom, for their counseling appointment. Now, unfortunately, after he learned that he was in the wrong location, because it was actually in this particular session was actually going to be in Roseville, and if any of you know kind of the Sacramento area, although it's only about 20 miles away, it can easily, if it's the wrong time of day, take you an hour or so to get from Folsom to Roseville. Also depending on where it's at. But anyway, suffice it to say he was in the wrong place and it was going to take him a good long while to get to where he was supposed to be. And he was very, very frustrated. He was angry. I mean, I've been there. I've been angry. I've been frustrated. And he made a statement, a sarcastic statement that, once again, in hindsight, he completely understands. He regrets having said it. But he made a regrettable statement. And the statement was, now, initially what he said was, well, I guess I'm just going to have to shoot myself. But that's not what he said. When they actually went back and looked at the records, what he said was, well, this is why people shoot themselves. All right? Once again, you're in a counselor's office, you're at a clinic, it's probably not the best thing to say, right? Needless to say, one of the employees called the police. Kind of hard to believe that wouldn't happen. So an employee of the clinic called the police, believing that this individual was a danger to themselves or others. So then after that, well, Mark was pulled over by the police. He was detained, and his family's firearm collection was seized. Now, I don't think I think it's debatable whether or not he should have been pulled over. I think it's debatable whether or not he should have. I think it's debatable whether or not he should have been detained. But then once again, he had his family's firearms were in fact seized, right? So following that process, Mark underwent a mental health assessment, and it was determined that he was not a threat to himself or others. Now, You would think that, okay, now that he's undergone his mental health assessment, that, well, that'd be the end of the story, right? That he got his goal, that he got his guns back. Nope. No such luck. The city of Folsom refused to release his firearm collection. And in fact, they filed a petition for their forfeiture on the basis that the possession of those particular firearms, he posed a danger to himself or others. In other words, they were afraid that he was probably going to kill himself or kill someone else with the firearms that he had. Now, he had a collection of, by the way, I almost forgot to mention. Now, this is an individual who has a concealed carry permit, right? So this is an individual who's undergone extensive background checks, interviews with the county sheriff. This is, by every definition, is a law-abiding citizen. He has no criminal background, no criminal history, no history of mental illness either. So all of this, once again, we're looking at all this. None of that stuff is there in his background or in his record. But they decided they're going to keep his guns anyway. So Mark got a lawyer. Now, when he went to court, all right, his case was so clear-cut that the judge didn't even have live testimony in the hearing, and he dismissed the city's petition. Now, it is important to understand why this is so important. So, first of all, it's important to understand that the police department decided that they were just going to have the officers send in written testimony, right? So they weren't even going to have their folks testify, right? Which was interesting, but they decided they weren't even going to, because there was the facts of the case were not in dispute. Everyone agreed, yeah, he went there, yeah, he was upset, and yeah, he said it. So no one disagreed with any of that. So the facts of the case, nothing at all was actually in dispute. But anyway, they decided they were going to do it. So when the judge basically read all of the information, he basically said, yeah, this is a bunch of hooey. I'm gonna throw out the petition. Give the guy his guns back. Mark Coleman got his firearms back, right? Nope, most definitely not. Here's what wound up happening. So the city of Folsom appealed the decision, right? So now this is before the appellate court. Now, they argued the following, and this is what they're arguing. So the first thing they're arguing was that Mr. Coleman never had an evaluation. He had an assessment. Now, this is important. This is important to understand, and this is why I keep telling people that in the war of words matter, right? There's a situation that happened here. So when someone is detained by officers, in California, if you get what's called a 5150, which is a 72-hour involuntary hold, right? You lose your gun rights for, I believe it's 5 years, right? But here's what happens. So they took him in. They got it. They went and got him. They took him. They detained him. They took him in. They did an assessment to determine whether or not he was a danger to himself or others. And the mental health professional said, nah, he's not a danger to himself or others. Now, the problem with their position, quite frankly, is this. Is that, see, you only get an evaluation once you've been admitted to determine whether you are a danger to yourself or others. So in other words, the assessment comes before you get committed. If you don't get committed, all you get is the assessment. You don't get an evaluation. But here's the funny part. So in order to permanently seize someone's firearms, you have to get a mental health evaluation. I know, seems odd, right? But this is what happens when you have people writing gun laws that don't stop to think things through, right? So in this particular case, he went, mental health professional saw him, interviewed his wife, determined that he was not a danger to himself or others, and that in fact, he was angry, he was frustrated, and made a frustrated statement and said, nah, he's not a danger, let him go. Well, so there is no evaluation that determines that he's a danger to himself or others. So you need to give him his guns back. But nope. They said because he got an assessment and not an evaluation, well, that doesn't really count. Well, okay, but you need the evaluation to show you need the evaluation to determine he's a danger to himself or others. Just because you didn't get it, someone has to determine he's a danger to. That's the point. Is someone has to determine that he's a danger to himself or others. And guess what? That never happened. So you need to give him his guns back. But nope, not interested. The second thing that they argued was the trial court erred by refusing to conduct live testimony in the hearing, despite it having served a notice of intention to introduce documentary evidence. Now, once again, that's what I said before. Documentary evidence is basically, okay, we're just going to give you written testimony because no one's really in dispute of the facts of the case. So then they turn around, and they use that as a means or as a reason to appeal. You were going to have your folks testify anyway. And so now you're going to, no, see this now we are bordering on the crazy, right? This is the problem with a lot of these laws, is that in most cases, and at least I'll give them in this particular case, there was a mental health professional involved, right? And the mental health professional decided he's not a danger to himself or others. And so he should have gotten his guns back. But see, this is what tells you this has nothing to do with mental health. This has everything to do with confiscating firearms. Because once the mental health professional told him he's not a danger to himself or others, why didn't he get his guns back? Because it was never about his mental health. It was always about confiscating his firearms. So the Firearms Policy Coalition filed a brief in the appellate court on Mark's behalf. All right, so basically what we argued in the court, I mean, I'm sure you probably already know. Number one, he was reviewed by a mental health professional. If you want to get caught over the semantics, the fact is he never would have gotten an evaluation. He wouldn't have gotten an evaluation because he was deemed to not be a danger to himself or others. He was never admitted. He was never committed. He was never committed. So that made absolutely no sense. He's never been determined by any mental health professional to be a danger to himself or others. Therefore, there's no reason for them to keep his firearms. The other thing that we argued was, dude, if you look at it, you said you weren't going to have anybody testify. So if you're not going to have anybody testify, he's not going to testify. And he's, by the way, not in dispute of the facts of the case. Then why do you need to have a live testimony? Nobody's position was jeopardized. Nobody was put at a disadvantage because everybody agreed, yeah, okay, those are the facts, and we've got all the information that we need. But the final thing is this, and this is probably the most important thing of all of this, and that is the unreasonable standard that is being set here for an individual to be able to get their firearms back. This is one of the biggest arguments we make in terms of red flag laws. No one tells you what exactly is required for you to get your firearms back. See, this was under the 5150 issue, whether or not someone's committed, but whether or not someone's involuntarily committed. But under red flag laws, in most cases, it doesn't set a standard for what it takes to get your firearms back. In fact, you go before the court guilty until proven innocent. So here's a guy who went to see a mental health professional, was deemed not to be a danger to himself or others, and the police still refused to give him his guns back. And people wonder why we're so up in arms over stuff like this. Folks, this is not something from some banana republic, unless you want to consider California banana republic, haha. But this is something that is happening today, 2020. This is not happening in Cuba. This is not happening in North Korea. This is not happening in the old Soviet Union. This is happening in 2020 in Folsom, California. And this is the reason why we fight against this stuff. So when people start talking about, we really don't want to take your guns, and things are going to be treated fairly, and you're going to be treated fairly, and there's things and protections in place. Well, guess what? Here's a guy who's spending thousands of dollars to be able to keep his fundamental rights. Oh, by the way, let me take a step back. By the way, it was so bad that even in the district court, they required the city to pay his attorney's fees. In the district court, that's how crazy their position is, and yet they still have not given the man his firearms back. They still are ignoring the courts and doing whatever the heck it is that they want to do. And y'all wonder why we raise questions. Folks, I will just tell you, and you guys know this, I'm a supporter of law enforcement. I really am. But ultimately what it comes down to is there's a balance between security and liberty. And law enforcement, those in law enforcement, those who support law enforcement, tend oftentimes to lean towards security, at the risk sometimes even of our liberties. Folks, it's up to us to stand. It's up for you and I to stand for our liberty. We have to stand up for it and not let some false security that they're going to try and put out there. They're going to try to say, oh, we need to do this for. No, we cannot allow them to do that, because ultimately, if they get their way, they would make sure that we have no firearms, right? They would make sure that we do not have the fundamental right to keep and bear arms, that we aren't able to exercise the human right of self-defense, because they believe that's their job, even though the courts have already said they don't have an obligation to do so. Anyway, folks, this is an example of not just the big picture, but even how it occurs and how it affects you on a daily basis. This is the sort of work that we do here at the Firearms Policy Coalition. I would hope that you would just take some time, follow the link in the description of this video, and make a donation. Support this case. Support us in this case. Support us in the other cases that we're working on. Once again, to help fight for your fundamental rights. Here's an individual whose rights were being trampled. And this is the chance for us to stand up for him and help him in his particular situation. But it's also vitally important because it also helps you. It also helps you and every other person who currently or may one day in the future decide to exercise their fundamental right to keep and bear arms. Folks, we need your help. We need your support. Support the Firearms Policy Coalition in our legal efforts today. Anyway, folks, that's going to be it for today's Coffee with Craig. We very much appreciate you tuning in. We appreciate you liking and sharing the program, telling your friends about the Firearms Policy Coalition. We are the home in the fight for civil rights. Got to use them, or you're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.